Our Dean of Law, Professor Penny Andrews, who began her studies here in South Africa at what was then the University of Natal, Durban, but then went on to Columbia University School of Law in New York. Penny's teaching career began more than 2 decades ago at La Trobe University in Melbourne, Australia, and she has since been tenured at 4 law schools. She is a member of the New York State Bar Association and the American Bar Association. Professor Andrews has published 4 books and more than 50 articles and book chapters focusing on international human rights law, comparative constitutional law, gender and racial equality, and the judiciary. She was appointed as UCT's new Dean of the Faculty of Law in January 2016, and therefore it's a huge honor to be able to welcome her here this evening.
Thank you, Fionnuala, for that introduction. And thank you, Matthew, for putting my speaker on. And good evening, everybody. So tonight, I normally know when I'm teaching constitutional law where everybody is in terms of their learning. So maybe it's a first year or second year and so on. So I don't know where all of you are in terms of your own careers, how many of you are lawyers, how many of you are constitutional experts and so on. So if I bore you to death because you know everything, I apologize, and I hope that for those of you who know nothing about constitutionalism or very little, I've tried to accommodate you all and sort of think about 20 years of constitutionalism in context, looking at the history and so on. Initially, I was supposed to be the third in the series, but the first speaker couldn't come, so my task has changed a little bit because this is the first night of the series, and Advocate Michelle Leroux is at the back there, and Judge Dennis Davies. Advocate Leroux is speaking tomorrow night, and Judge Davies will be ending the series and wrapping things up. You know, he's a good wrapper-upper. And I'll introduce the topic. So, what I'd like to do is just tell you what I'm going to be talking about this evening, and hopefully I can leave some time for questions. So when we talk about 20 years of constitutionalism, it's useful to go back to that time between 1990 and 1994 and look at some of the factors around the negotiation of the Constitution, because today, as you know, we are going back to not just the context of the Constitution, the content and so on, but also some of the decisions made at that time. So it's good to go back. And then the second thing I will deal with is the international context. Because South Africa was such a the anti-apartheid struggle was such a global one, and because the Constitution in many ways reflects half a century of human rights activism, constitutionalism, and so on, that one cannot ignore the global context when thinking about the South African Constitution. And in fact, Judge Davies once commented to me that between 1990 and 1993, after the interim constitution was drawn up, that South Africa felt like sort of an ongoing constitutional and international law workshop. And I, at that point, was living in the United States, in New York. I met many, many American lawyers, and I've subsequently met many American lawyers who tell me very proudly that they wrote the South Africa Constitution. So it really is a global product, and in fact, probably the most anticipated and most admired constitution of the 20th century, the late 20th century. Then I will look a little bit again at the controversies of the Constitution. What were the issues that stalled? What were the issues that were the most difficult, and so on? And whether those controversies have settled or whether we are revisiting them again and should revisit them. And then I will look at very, very cursorily at the provisions of the Constitution, and then some of the constitutional court cases around gender equality and the issue around gender equality, because that's close to my heart when I think about the South African Constitution and what I really, when I look back 20 years ago, if I had to write a letter to my younger self, it would have been, did women's lives change as a result of the Constitution? So that's the roadmap for tonight. I hope I can get through all of it and that we can have a good discussion about these issues. So, before the Constitution, so we all know the announcement by then President de Klerk. Most of us sort of knew where we were. There's the announcement by F.W. de Klerk, and then there's the O.J. Simpson verdict. There are a whole bunch of moments where we thought we knew where we were. So on the February 2nd, 1990, there was the announcement to release Nelson Mandela, to unban the PAC, the ANC, the Communist Party, and other such organizations, lifting the state of emergency, release of political prisoners. So February 1990, very, very important in terms of our constitutional development. Then between 1990 and April 1994, it's hard for us to imagine that time, a time of incredible anticipation and excitement, but also a time of great violence. Lots of talks about talks before 1990 and after 1990. And we recall CODESA, the Convention for a Democratic South Africa, which went for a few months and then broke down. And of course, we remember the late Judge Ismail Mohammed, who chaired CODESA and so on. And then again, in the picking up of the negotiations through the multi-party negotiations process. And the end result was the interim constitution. The interim constitution comes into force in April 1994. We have an election, and then we have the drafting of the 1996 constitution through the Constitutional Assembly with a set of constitutional principles that had been determined through the transitional constitution. And then, of course, we have the confirmation by the Constitutional Court of the Constitution. Again, an exciting and very, very important moment in our 2 decades of constitutionalism. So the international context, because I think the international context very much plays into our Constitution, the Bill of Rights, the kinds of choices that we made. So in 1989, just before the release of Nelson Mandela and the unbanning of the ANC, we sort of essentially have the collapse of socialist and communist economies, the collapse of the Berlin Wall. You see a sort of major shift in global politics. And at that particular time, the language of rights, human rights, and the rule of law and so on, became the language of progressive politics. And whereas up until that time, the issue of redistribution of wealth, the idea that we would in South Africa, we were working towards the end of apartheid, and a government that would be committed to redistribution. In fact, what happened in 1989 essentially ended that. And the issue was about rights. So there's been a lot of literature around the question about rights, language, replacing redistributive language. And sort of the rights discourse became the lingua franca of progressive politics. And that, to some extent, provided those who were going to negotiate with the apartheid government, and particularly the ANC, with a very limited paradigm within which to negotiate, because at the same time, the sort of Washington consensus as we saw it emerged. There was the triumph of liberal democracy, the triumph of capitalism. We had Gorbachev with perestroika. And so those international, those global issues deeply impacted the capacity of those who negotiated, and particularly the ANC and the PAC and some of the lesser parties, to make the kinds of demands that had been part of, there was a staple of the liberation movement. So what were the controversies at the time? What were the stumbling blocks? The question of minority rights loomed very large. And minority rights mostly around Afrikaner, the Afrikaner minority or the white minority, but also to some extent other minorities. Then there were questions about property and land, and the question about how to protect property while at the same time making it possible for people whose land were, where there had been sort of land grabs in an earlier period, how that was going to be dealt with. And so property, land, and to some extent the question of social and economic rights loomed large as well. And particularly around issues of justiciability. In other words, whereas in most constitutions of the world, and particularly the ubiquitous American Constitution, social and economic rights were really not seen as fit and proper for a constitution. And in South Africa, in fact, this was clear that social and economic rights had to be included, but would we go the Indian way and have social and economic rights as sort of optional, or certainly not justiciable in the way that we did eventually decide. So that was also a controversy. Then the question around the provinces and the Bantustans. How was the Ciskei, Transkei, Bophuthatswana, and so on going to be incorporated in South Africa, the provincial questions and so on, and maybe the speakers later on this week will touch on more around these questions. And then the system of government. What was representation going to look like? Would we follow the sort of model that was adopted in most Western democracies, and particularly the United States? One person, one vote, proportional representation. There were different models, the New Zealand model, the Scandinavian models, and so on. And then finally, the question of what to do about the crimes of apartheid. And apartheid had been declared a crime against humanity in 1977 by the United Nations. And the issue of what to do about apartheid crimes and about this system was one of the controversies, obviously. And at that time as well, there'd been a lot of talk around international criminal justice and an international criminal court and Nuremberg-style approaches and so on. And then, as we know, what we ended up with was something around truth and reconciliation. So those were sort of the background questions. Those were sort of in 1994. And if we recall, there was an extraordinary amount of violence. Lots of people immigrated. There was a sense that South Africa was going to hell in a handbasket, that there was going to be a racial war, that it would be impossible for South Africans, black and white, to come together to develop and assist in the emergence of this new democracy. Well, at that point, in 1994, April 1994, probably was a global event of incredible significance. Everywhere in the world, people watched the elections. Nelson Mandela became extraordinarily popular. He became the symbol of reconciliation and so on. One saw those photographs. I was living in New York at the time, the photographs of people, the snakes of people voting. And there were some very poignant moments at the voting. I remember reading a report about a woman in somewhere in the northwest, in what's now Limpopo, who was maybe 70 years old, what did voting mean to her? It was the first time in her life that she picked up a pencil to make a mark. So there were all these incredibly poignant moments about democracy. So it's huge, huge romanticism. And I came back to South Africa between June and December 1994, and the euphoria was unbelievable. I would think about that time and how excited everybody was and so on. So the preamble to the Constitution reflects, I think, that optimism, the idea that we really, this society was going to be a transformed one, and that our past was never going to happen again, and these values were going to be so much part of who we are. So the preamble to the Constitution talks about recognizing the injustices of the past, honor those who suffered for freedom, and so on. And the idea that South Africa belongs to all who live in it, united in our diversity. I have to say that often when I deal with students around questions around race and belonging and so on. So what were the sort of the aims in the preamble? The idea was to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights, lay the foundations for a democratic and open society, improve the quality of life of all citizens and free the potential of each person, and build a united and democratic South Africa. And so I guess the question one asks after 21 years, you know, how have we done this preamble? Can we say that that the foundation for a democratic and open society, for example, is pretty strong and so on? So these, I think, are some of the questions that one raises in the discussion. Of course, our Constitution is 20 years old, 21 years old. The American Constitution is 200 years old, and look how they're struggling with some of the same issues that we're dealing with. So to some extent, I feel a little, you know, if you think in the life of a person at 20, you barely know yourself, you're still youthful, so to some extent to ask these questions seems almost premature. All right, so I'm going to just run through the Constitution because we're not going to be able to cover every part of the Constitution. There are so many. The Constitution is made up of 14 chapters and a preamble. And I think that, you know, we can't do justice to it, but I just thought I'd sort of list the Constitution so you can see how incredibly overwhelming it is. It covers every aspect of our life, of our political life. And there is almost nothing, there is nothing that the Constitution doesn't cover. So I've listed there the Bill of Rights, Parliament, etc., local government. You can take a quick look at that list. And then courts, public administration. You're probably all familiar with the so-called Chapter 9 institutions, particularly the Public Protector's Office. The Public Protector's Office is a very important Chapter 9 institution, the Human Rights Commission, the Gender Commission, and so on. So that's the sort of Constitution covers everything. So to some extent, there's probably nothing in our public life, and even, I would argue, in our private life, that doesn't fall within the ambit of the Constitution. The Bill of Rights is the most important. From our move from apartheid to democracy, the Bill of Rights is crucial. And I had this conversation with somebody the other day, and I mentioned it in my lecture on Saturday night as well, that this idea that we could have this document and move from a culture of apartheid, which was a racist culture, a sexist culture, an authoritarian culture, to one of democracy just by the adoption of a constitution was fantasy. And I think that's one of the reasons why we struggle so much, because the culture of human rights is far more than the Bill of Rights and what it entails. But I think it is important certainly to allow us to work towards what the Bill of Rights says and promises. So the Bill of Rights includes the right to equality, which is absolutely important, that people, women, sexual minorities, blacks, etc., have the right to equality and the right not to be discriminated against. Very, very important in our Constitution, our Bill of Rights, is the right to dignity. And in fact, the right to dignity, in many ways, one could argue, allows for everybody, even those who are not identified in the non-discrimination grounds, to be protected by the Constitution. Civil and political rights, the classic right to vote, right to freedom of expression, etc. And then social and economic rights. And this is very, very important, particularly when one thinks of gender equality, but not only linked to women. The right to bodily and psychological integrity, and personal security and freedom from violence, which is very much a part of our Bill of Rights and not necessarily captured in many, many constitutional documents, particularly other bills of rights. Then the sort of cultural and religious issues, as I said, this was also something that created great controversy. What to do with indigenous institutions like chieftains and so on, what to do with indigenous practices, etc., indigenous laws. And so the Constitution, the Bill of Rights, very, very clearly states the right of everybody, religious and indigenous minorities, to pursue their cultural or their religious values, but all must not contradict equality. So equality is centered as the most fundamental of the values, and in fact allows for some way to think about these questions that really incorporates many, many divergent viewpoints and many, many divergent aspects towards the practice of indigenous culture or religious culture. So I just had this picture. This was, remember when Nelson Mandela was the president of the world? I love that Sapiro cartoon. That sort of captured the moment when we'd written our Constitution and so on. So the Constitution has been described as transformative, and in fact it has to be transformative. For South Africa, arguably, the idea of the adoption of this document was not just a formal sort of everybody's agreed to something and we just continue our lives. This really was about disrupting and completely overthrowing relationships, social relationships, economic relationships, and so on. And Carl Clare, the American scholar, has written a seminal article on transformative constitutionalism. And in his article, he argues about the capacity of the Constitution to really transform people's lives and for us to really move away from our previously authoritarian and racist society. It's one of the most cited articles of the Constitution. And then Makau Matua, who's a Kenyan scholar based in the United States, has looked at South Africa and looked at the attempt to develop, to craft a human rights state. And in fact, South Africa, arguably at the end of the 20th century, was the place where many, many international activists, human rights activists, could sort of foresaw the sort of utopian, human rights utopia, and the idea that the Constitution would lead somewhere. Now, Makau Matua is a little more skeptical. He actually, and I go back and read his work, because he was cautious. He really asked us in his article to think a little bit more skeptically and to be a little bit more critical, because we were so euphoric about the possibilities of the Constitution. And other scholars, Upendra Bakshi and Boa de Sousa Santos, have written really about the moment when human rights usurped all other ethical discourses, and the idea of talking about redistribution, talking about socialism, etc., was no longer possible. And then Christina Murray and Kathy Albertine, two South African feminist scholars, have argued in some of their work that the Bill of Rights and the Constitution, particularly the idea that the Constitution outlaws gender equality, but not just in this sort of way that it historically has in the American Constitution, for example, or others, but it talks about direct and indirect discrimination. It talks about intersectionality, the idea that gender and other forms of discrimination can play a particular way of disadvantage and so on. So they've argued that the South African Constitution provides for a peculiarly kind of South African legal feminism. So just to talk a little bit about the starting point of South African constitutionalism again, which is about its uniqueness, that it's South Africa's constitutionalism and the constitutional project differs particularly from the American Constitution, but others as well. And this is, firstly, that whereas most constitutions talk about, and particularly bills of rights talk about the relationship between government and citizens, the South African Constitution actually talks about relationships between individuals. And all of us know that it's in the private sphere where discrimination is the most pernicious and it's the hardest to eradicate. So this idea of horizontality and vertical approaches to eradicating discrimination. So in this way, the South African Constitution is unique. It's looking at the relationship between government and citizens, but also citizens and citizens. Then, as I said earlier, the South African Constitution embraces social and political rights as social and economic rights as justiciable, and not just the classic civil and political rights. The third thing about the South African Constitution that's quite remarkable is that if you look at the Constitution, the text of the Constitution, and the Constitutional Court judgments, particularly the first few judgments, but also this has been a continuous theme, that there has to be a derogation from the status quo. That within the status quo, the Constitution is embedded in racist and sexist and authoritarian tendencies, structures, institutions, and so on. And it's the task of those who interpret the Constitution to ensure that there's derogation from the status quo. That's very different from the American Constitution, where the Supreme Court, if you go to the United States Supreme Court, you had better argue very, very clearly and very compellingly that you need to derogate from the status quo. So, for example, there's the idea of strict scrutiny if you challenge a law that discriminates against black people. You have to provide very, very compelling argument that the status quo, in fact, and that it's not just that there's an intent to discriminate, but also in fact, you have to show an intent to discriminate, which is very, very difficult. So the levels of scrutiny in the United States, particularly around racial equality and to a lesser extent gender equality, is much harder. And so this idea, the South African Constitution is in fact much more open and much more accessible to people. And the other thing is that the South African Constitution also, there's a two-prong approach to showing discrimination. And if you're part of a group that's protected, there is a presumption that there's discrimination, and then the burden shifts to the person who is the discriminator to show that the discrimination, in fact, is fair. So the South African Constitution, in many ways, as I said, recognizes and requires derogation from the status quo. The question is, of course, when does this end? 10 years, 30 years from now? And one also sees this in relation to affirmative action and redress measures. At what point affirmative action is protected in the Constitution. We know that in the United States, affirmative action cases have been fought hard. There have been many, many affirmative action cases before the US Supreme Court. The US Supreme Court is actually not sympathetic to affirmative action, but affirmative action is protected in our Constitution. The question then arises, at what point when things shift demographically, what do we do about affirmative action? And then the other thing that makes South Africa's constitution so unique is its consideration and its inclusion of international and comparative foreign law. So the Constitutional Court and other courts can consider international law and foreign law. All right, so what I thought I would do is just sort of background, just talk a little bit about how the Constitutional Court has, in fact, in many ways, tried to fulfill the promises of the Constitution through some of its earlier cases, and particularly around gender equality. The Constitutional Court's decisions around gender equality, for the most part, have been, certainly in my opinion, have been quite impressive. The Constitutional Court has really tried to give effect to a substantive equality, not just a formal equality. And I think that much of the Constitutional Court's jurisprudence, not all, but much of it has been admired and quoted by many courts, but also by feminist scholars and so on. So let me just talk a little bit about a few cases that I think highlight the possibilities of the Constitution and how the Constitution can make a difference in people's lives. So the Hugo case was one of the earliest cases. And this was a case involving a man who, there had been a presidential pardon. Nelson Mandela, at his inauguration, pardoned all prisoners, all female prisoners who had children under the age of 12. And Peter Hugo was sitting in prison, and he had a child under the age of 12, and he claimed that the presidential pardon violated his constitutional right, that he had been discriminated on the basis of his gender. And the court's decision, there are many different decisions. Catherine O'Regan's decision is particularly interested. But what the court tried to do in that case was really look at the context within which the presidential pardon was made, and what were the factors that contributed to the president choosing only to pardon women. And the court gave a very interesting judgment. As I said, Judge O'Regan's decision sort of looked at this question of equal treatment. Do you treat people the same? If you treated men and women the same in this, well, you wouldn't take notice, for example, of the fact that most women, or women disproportionately, bear the burden and the brunt of child rearing and childbearing, and that there were far more single-headed households, female-headed households than men. So they looked at this in a sort of contextual way, and basically felt that even though there had been discrimination, it was actually fair because of the lived reality of people's lives, and particularly women's lives, because women were the main caregivers of children. And they also felt that men could individually apply for the pardon. That was part of it. And then one of the judges, as an aside, also spoke about the high crime rate in South Africa and what would have happened if President Mandela had pardoned everybody who had children under the age of 12. It's an interesting judgment because it is the first time that the court comes to sort of talks about substantive equality, about not just the idea that there's formal equality, you treat people equally and the same, that you really need to look at the reality of people's lives and the context of people's lives. Judge Krichler wrote a very powerful dissenting judgment, and he felt that the judgment would that the majority judgment would reinforce stereotypes about women, and he basically took the approach of the American courts that it was discrimination and it was unfair. Now, another interesting case is Fraser versus Children's Court, and the late Justice Mohammed wrote this decision. It was a case involving adoption of children, and children who were born in wedlock required for adoption the consent of both mother and father. But a child born in the old days, an illegitimate child, a child born out of wedlock, required only the permission of the mother. And a father brought this claim and claimed that this law discriminated against him on the basis of his gender. And Judge Mohammed found that it actually did. And he found it in this way. He said there are many marriages in South Africa, Muslim marriages, some African customary marriages, that are not recognized in law. And that the fathers, in fact, do have relationships with the children, are, in fact, for all intents and purposes, married. And because there are so many different forms of marriages in South Africa, many not recognized that this did discriminate against fathers. And so he found that there had been discrimination. But I thought it was an interesting, particularly in the wake of Hugo and so on. And then Bay, Gumede, Shilubano, these are cases involving indigenous customary law, African customary law. If you go through the decisions of the Constitutional Court, you'll see that the court has not dealt with these questions. Not many cases have come before the court dealing with African customary law. And the courts have, for the most part, obviously looked at the issues in a very, very sympathetic way, but have centered gender equality. So, for example, a law that discriminated, an inheritance law that discriminated against girls, or one of the cases involving a customary marriage, the court was very mindful of the rights of women. So the court has looked at African customary law clearly with gender equality as the goal. Here's just an aside. There haven't been many cases before the Constitutional Court on racial discrimination. There have been many, many cases on gender equality and so on, but racial discrimination and African customary law, not so much. And then there was one of the provisions of the Constitution is that the common law must be developed in light of the constitutional principles. In fact, the values of the Constitution must infuse the common law. And this was a case involving the law of delict, in which a woman had been injured by somebody who was out on bail, somebody who was dangerous. Now, before that case, and this is the situation in many places, many countries, you cannot hold the state liable. And the state is immune from injuries that a private individual has inflicted upon you. However, if there's a duty under tort law, under delict, if somebody injures you, you look at the question of whether the person has a duty, and of course whether when they failed that duty, it caused you harm. And in this case, what the court did was hold the police and the prosecutor accountable for their failure to arrest this person, because what had happened is the complainant here had gone to the police and said, this is a dangerous individual, I fear for my life, and the individual attacked her. And so under Carmichael, you see the courts develop a doctrine whereby you see the Constitution incorporated into common law. And then the Grootboom cases and the Treatment Action Campaign case, you all know about the Grootboom, the Right to Housing case, and the Treatment Action Campaign case in which the government was forced to roll out a nevirapine to HIV-positive pregnant women. Now, I think that the social and economic rights cases have the greatest capacity to change the lives of women. Under gender equality, one really needs to focus on, I think, the economic obstacles to women. So that's just a very, very short synopsis of the constitutional cases. So gender equality, I sort of think about gender equality and the Constitution. And the way I've tried to think about how the Constitution impacts women's lives is this question of citizenship. How do women experience citizenship in South Africa in the post-apartheid era, in the new constitutional era? So the argument, many feminist scholars have made the argument, of course, that citizenship is more than political representation and voting. But for women, there are clearly three interconnected aspects of citizenship. And the first is about equal access to economic resources. How does the Constitution respond to this? What are the obstacles, the impediments to women really having equal access to economic resources? The second question has to do with freedom from violence. And in the Constitution, we see that personal security and freedom from violence is protected, and then freedom from subordinating cultural practices. So when one looks at South Africa today, if you look at all the indicators, all the data suggests that women disproportionately, and particularly black women, are still at the bottom of the economic rung. The Constitution has made a difference for certain women, but it's a very, very narrow band of women who have been able to benefit from the Constitution, the promises of the Constitution. Violence remains one of the biggest obstacles to women experiencing the benefits of the Constitution. And violence impacts people, as we know, differently. If one looks at the statistics on rape, for example, everybody says, well, anybody can be raped and anybody is subjected to domestic violence. But the research shows, for example, that poor women who have to walk long distances to bus stops, who have to get off trains and stations that are not protected by security and so on, are much, much more liable to be attacked, are much, much more likely to be victims of rape, etc., etc. And similarly with domestic violence, clearly everybody can be the victim of domestic violence, but there are ways in which women with resources can respond in ways that will alleviate some of the consequences, the negative consequences of domestic violence. Then the third is this issue of subordinating cultural practices, and this is always, to me, sort of the whole issue of culture is ground zero of feminism, because so often, whether it's in South Africa or elsewhere, the debate about gender equality often sort of meets the obstacle of culture, cultural rights. And it's not just a question of men and women, because there are women who support what I would call subordinating cultural practices. Then there's the question, who determines what is a subordinating cultural practice? So lobola, do we think, who thinks lobola discriminates against women, objectifies women? You'd find many different women have very different approaches to lobola. Polygamy, our president is a polygamist. Polygamy is protected in the Recognition of Customary Marriages Act. There'd be many people who'd look at polygamy and say this practice really represents the subjugation of women. So I think that cultural practices are incredibly difficult. It's very, very hard to talk about gender equality. But we do know that cultural practices impede women's right to equality. And if you look at the combination of cultural practices, freedom from violence and equal access to economic resources, you see that women's ability to benefit from and enjoy the promises of the Constitution are circumscribed. So I sort of end there. I like this picture of Mandela, President Mandela, when he died. I think about, have we now, 20 years later, maybe sort of missed that moment when we thought our Constitution was going to promise much. But anyway, so if you have any questions, comments, I'll be happy to answer them. Where's the light? Can you put on the light? Yes.
For a constitutional decision to be made, does it have to be brought by an individual, or can it be a group that challenges a given practice or law?
I think for a constitutional case to be brought, it can be a group, it can be an individual. The rules around standing is quite expansive. Judge Davies, right? The rules around standing under the Constitution is very, very, so a group that's affected can bring a case before the court.
A follow-up to that.
Yes.
So would anything change if that case were not brought? It would stay the same unless the case were brought? Is a law being made that covers those issues anyway?
I think it depends on the issue. So, for example, Mrs. Grootboom, the housing case, Mrs. Grootboom brought the case because she and members of her community were living in deplorable conditions and they had been evicted, etc., etc. And the court essentially instructed the government to put in place a policy that accommodates and caters to the most needy in South Africa. Well, Mrs. Grootboom died before she got her shack or a house, because between local, provincial, and national government, really not much was done. They eventually did roll out a policy, but she didn't benefit. And you contrast that to the treatment action case, where there was a very, very active campaign by the treatment action campaign, in my opinion, is the most successful post-apartheid organization. So the case was brought to enforce the government to roll out nevirapine to HIV-positive pregnant women in public hospitals. And in that case, the court instructed the government to do so, but it was not the same as Mrs. Grootboom. The TAC, made sure that the Minister of Health and government actually did what it did. So I think it makes a difference. Things change when you have an advocacy campaign, when the conditions are such that the judgment of the court can be given effect to. And then there be cases in which the government has been told to change the law within a year or something like that. So it just depends on the facts, the circumstances of each case. Yes?
On the gender issue, have there been any progressions in transgender issues at all?
I have not come across transgender cases before the Constitutional Court. Michelle and Dennis, have you? I don't think the issue has come before the Constitutional Court. No. I assume it will at some point come before the court, but it hasn't. Yes?
I'm just interested in the relationship between what happens in common laws or ordinary courts and the Constitutional Court. So if the Constitutional Court makes a decision, does that influence decisions that then get made?
Further down? Yes, it does.
Automatically?
Well, as the cases come up, it does change the law to the extent that the Constitution has made the decision, that the ruling is there. And then what happens, like in the Carmichael case, the court went back to the lower court to make the finding in light of the Constitutional Court's holding. So it changes as again, depending on the case, it changes as cases are brought before the court, unless the government is asked to change the law around a particular issue. But of course, you raise an important point, that when one talks about the Constitutional Court in cases anywhere, any of the courts, the Constitution is only available to people who have the resources and the knowledge that these rights are there and that they can exercise those rights. So I think that this is the most difficult issue, or one of the most difficult issues that we confront here, that not enough people have access to the courts, number one. Second, maybe the courts aren't the best places where people can have their claims heard or where they can be listened to, but clearly the courts have become very, very important sites of struggle. But I think that it's about, as well as about the culture of rights, how we conceive of the rights in the Constitution and how we want to practice those rights, and so on. But I think access to the courts or access to justice is a difficult question, because so many people don't know, because of poor education and so on, that there are certain rights to which they're entitled, and they can't exercise those rights for all kinds of reasons. Yes?
Can I just raise an issue? I had a matter today in one of the bargaining councils, and it concerned a woman who's a welder, who's a level 2, that's 1 up, qualified welder. She doesn't live in Cape Town, she's not unionised, she lives in Durban, and she's deployed on projects all over the country. And because she's skilled, her hourly rate is fairly high. and she was one of 40 people, all men except for her, on a public sector project. Her employer is private sector. The employer didn't bother to pitch for the conciliation meeting today. And she worked for a day. At the end of the first day on a 4-month project, she was told, don't come back tomorrow, they have no need of you. She didn't understand why, and upon inquiry, it was reported back to her that the supervisor had said, I don't want that lesbian bitch on site. Whether she's a lesbian or not is quite irrelevant, I didn't inquire. But the point for me, apropos the previous intervention, is she's not marginalised because she's skilled. She's thoroughly marginalised by the status of her work, which is project-based and peripatetic, and also because she is unaffiliated and she's in a town which is not her own. So I sent her to the Women's Legal Centre this afternoon, and I gave her a whole lot of cases, and she's a clever girl, and she's got access to Google and so on. So she will benefit, I think, from the opportunities occasioned by this half-an-hour conversation this afternoon. But she was lucky that she got to the council and that, I had time on my hands because the employer didn't pitch. So I was able to explain some things. But absent that opportunity, somebody in her position would be left thoroughly disconnected from the substantive and procedural rights to which she's entitled. So I just thought I'd add that.
Well, the gentleman, and I'm using gentleman very broadly here, who had the good sense actually to sort of articulate what is but very often in situations like that, I mean, gender discrimination, sex discrimination is often unstated. It's very, very hard for women to show.
Well, he was confident to make his opinions known because he wasn't talking to her. He was talking about her in the third person as a sort of anonymized different point. Yeah. No, I think that I'm not surprised at her. But you'd think in 2017 that somebody would be that blatant. Was this Cape Town? Yes. Yeah, right. Well, Trump's not embarrassed.
Yeah, that's true. Yes. So we should feel proud it's a global, Trump's going to make all of us feel good. And he certainly makes, sexists feel good. Yeah.
Just in general terms, if somebody is aware of their rights and has a case they feel, what are the actual hurdles that a person or a group has to go through to get their case heard at the Constitutional Court?
Well, if you say somebody's not aware of their rights.
If they are aware,
yes.
They know they have rights, they feel they've been discriminated against, but then what other things do they have to go through to actually get heard?
Well, I mean, firstly, if somebody has the resources, then clearly they can appoint, get a lawyer, and, or if somebody has, like the gender equality issues, the Women's Legal Centre and so on, they're places where a woman who's been discriminated against and who doesn't have the resources can go to the Women's Legal Centre. A person who's squatting someplace or a poor person go to the Legal Resources Centre. So it just depends on so who the person is. But the case has to go first. Almost no cases go straight to the Constitutional Court. It goes first to the High Court and then makes its way up, to the Supreme Court of Appeal and then the Constitutional Court. There have been cases where they've gone straight to the Constitutional Court. Issues of great significance, right? A very, very important question, like the death penalty. Outlawing the death penalty went straight to the Constitutional Court. But for the most part, it's got to go through the different levels of court before. And most cases do not get to the Constitutional Court. They dealt with, most people experience justice in the magistrate's court, in fact. But certainly, claimants don't all get the right to go to the Constitutional Court. Yes?
Do any constitutions or countries deal with ageism? We've got the situation here at UCT and many other places where we were forced to resign at 60. But you're going to be
the Constitution, but in the United States there's the Age Discrimination Act. So there's no retirement age. People can stay, and I know I've taught at universities there for a long time. There's some people who literally get wheeled out of their offices. So I sort of have a, my approach to this is, I do think that a cut-off age like 60 or 65 really, you know, that there should not be a retirement age. But I don't think it should be, you know, people, it's clear that at some point you need to create the space for younger people, particularly at universities, to come up and so on. But yeah, it's not, in the United States, it's probably the only country I know that has age discrimination legislation, maybe other places. No, in France, they fight for the right to retire earlier. So, yeah. So I don't know about constitutional protections. Yes?
Does it fall within the scope of your lecture tonight to comment on some of the disappointments that you have personally experienced from the Constitutional Court, and perhaps what changes you might think are coming down the track at us, constitutionally speaking?
For the most part, there's, you know, maybe I'll ask the other speakers, the two of them for tomorrow night or the next night. You know, I focus mostly on gender equality. And I cannot think of a case in which I was so outraged. In fact, most of the cases I've used when I was teaching international human rights law, for example, and gender equality. I've used the cases to demonstrate how you can pursue gender equality through constitutional interpretation. So I can't think of anything that, any of the gender equality cases, but there may be other cases, there are a range of cases I know in the commercial area and so on where people have been disappointed. The death penalty case, I'm thinking of the sort of larger cases. And, you know, for the last few years, I've not paid attention to much other than particularly just gender equality. But you can ask Advocate LaRue tomorrow night, and then you ask Judge Davis on Friday night. Yes.
So, not so that a stupid question, but if the law says there's equality for everybody, why would one need gender equality?
Because gender equality has a particular flavor and has particular consequences, and because sexism is so much part of the way that we form our lives, the way we organize our lives. The idea.
From a legal aspect.
Well, from a legal aspect, it's to stop cultural and social practices that discriminate against women. So the idea is that the Constitution and the Bill of Rights is there to ensure that everybody enjoys citizenship, equal citizenship. But most of the discrimination happens through social and cultural and sometimes political practices. It's very, very easy to get rid of gender discrimination sort of in a public way. Nobody says, well, people still say, I don't want to appoint that woman because she's a woman. But I think that sort of gender equality and gender discrimination has a particularly durable, it's a durable life. I would argue that for the most part, even though we still deal with racial discrimination in South Africa, racial discrimination is much easily eradicated. Gender discrimination, sex discrimination is much harder because it's so much part of the way we live our lives. It's so much part of our personal relationships and so on. So yes, we do need gender equality, because when all kinds of other kinds of discrimination, well, they won't fade away, because I think as human beings, we'll always discriminate on different grounds and so on. But the idea of gender equality is to try and attack structural discrimination that result from these attitudes. So I think that, I can't imagine that you could think of equality today without thinking about gender equality. There was something, all the marches around the world this weekend, against the Donald Trump inauguration. Today on Facebook there was a post by a young woman who said she really criticized all these feminists who had organized the march and so on, and she says, I don't have to march, my life is good, I can have a job I want, all of this. And so her post was sent around the world. And then there was a rebuttal from somebody who forwarded to me to say, yes, your life is good, you have a wonderful life, you can have a job and so on. But have you thought about this woman who's got 2 children, who's a single parent, who doesn't always have a right to a job, or who lives in a poor neighborhood, etc., etc. So I think, these are there's a lot of conflict around these attitudes and ideas. And not all women are similarly situated. I mean, I would never, a woman who's a dean of a law school is not in the same place as a woman who works, on the one of the wine farms in Stellenbosch, or is a laborer someplace in a factory. So it's not to say that all women are similarly situated, but women, as we recall CODESA, the Convention for a Democratic South Africa, which went for a few months and then broke down. And of course we remember the late Judge Ismail Mohammed, who chaired CODESA and so on. And then again in the picking up of the negotiations through the multi-party negotiations process. And the end result was the interim constitution. The interim constitution comes into force in April 1994. We have an election, and then we have the drafting of the 1996 constitution through the Constitutional Assembly with a set of constitutional principles that had been determined through the transitional constitution. And then, of course, we have the confirmation by the Constitutional Court of the Constitution. Again, an exciting and very, very important moment in our 2 decades of constitutionalism. So the international context, because I think the international context very much plays into our Constitution, the Bill of Rights, the kinds of choices that we made. So in 1989, just before the release of Nelson Mandela and the unbanning of the ANC, we sort of essentially have the collapse of socialist and communist economies, the collapse of the Berlin Wall. You see a sort of major shift in global politics. And at that particular time, the language of rights, human rights, and the rule of law and so on, became the language of progressive politics. And whereas up until that time, the issue of redistribution of wealth, the idea that we would in South Africa, we were working towards the end of apartheid, and a government that would be committed to redistribution. In fact, what happened in 1989, night of the series, and Advocate Michelle Leroux is at the back there, and Judge Dennis Davies. Advocate Leroux is speaking tomorrow night, and Judge Davies will be ending the series and wrapping things up. He's a good wrapper-upper. And I'll introduce the topic. So, what I'd like to do is just tell you what I'm going to be talking about this evening, and hopefully I can leave some time for questions. So when we talk about 20 years of constitutionalism, it's useful to go back to that time between 1990 and 1994 and look at some of the factors around the negotiation of the Constitution, because today, as you know, we are going back to not just the context of the Constitution, the content and so on, but also some of the decisions made at that time. So it's good to go back. And then the second thing I will deal with is the international context. Because South Africa was such a global, the anti-apartheid struggle was such a global one, and because the Constitution in many ways reflects half a century of human rights activism, constitutionalism, and so on, that one cannot ignore the global context when thinking about the South African Constitution. And in fact, Judge Davies once commented to me that between 1990 and 1993, after the interim constitution was drawn up, that South Africa felt like sort of an ongoing constitutional and international law workshop. And I, at that point, was living in the United States, in New York. I met many, many American lawyers, and I've subsequently met many American lawyers who tell me very proudly that they wrote the South Africa Constitution. So it really is a global product, and in fact, probably the most anticipated and most admired constitution of the 20th century, the late 20th century. Then I will look a little bit again at the controversies of the Constitution. What were the issues that stalled? What were the issues that were the most difficult, and so on? And whether those controversies have settled, or whether we are revisiting them again and should revisit them. And then I will look at very, very cursorily at the provisions of the Constitution, and then some of the constitutional court cases around gender equality, and the issue around gender equality, because that's close to my heart when I think about the South African Constitution and what I really, when I look back 20 years ago, if I had to write a letter to my younger self, it would have been, did women's lives change as a result of the Constitution? So that's the roadmap for tonight. I hope I can get through all of it, and that we can have a good discussion about these issues. So, before the Constitution, so we all know the announcement by then President de Klerk. Most of us sort of knew where we were. There's the announcement by F.W. de Klerk, and then there's the O.J. Simpson verdict. There are a whole bunch of moments where we thought we knew where we were. So on the February 2nd, 1990, there was the announcement to release Nelson Mandela, to unban the PAC, the ANC, the Communist Party, and other such organizations, lifting the state of emergency, release of political prisoners. So February 1990, very, very important in terms of our constitutional development. Then between 1990 and April 1994, it's hard for us to imagine that time, a time of incredible anticipation and excitement, but also a time of great violence. Lots of talks about talks before 1990 and after 1990, and essentially ended that. And the issue was about rights. So there's been a lot of literature around the question about rights, language, replacing redistributive language. And sort of the rights discourse became the lingua franca of progressive politics. And that, to some extent, provided those who were going to negotiate with the apartheid government, and particularly the ANC, with a very limited paradigm within which to negotiate, because at the same time, the sort of Washington consensus as we saw it emerged. There was the triumph of liberal democracy, the triumph of capitalism. We had Gorbachev with perestroika. And so those global issues deeply impacted the capacity of those who negotiated, and particularly the ANC and the PAC and some of the lesser parties, to make the kinds of demands that had been part of, there was a staple of the liberation movement. So what were the controversies at the time? What were the stumbling blocks? The question of minority rights loomed very large. And minority rights mostly around Afrikaner, the Afrikaner minority or the white minority, but also to some extent other minorities. Then there were questions about property and land, and the question about how to protect property while at the same time making it possible for people whose land were, where there had been sort of land grabs in an earlier period, how that was going to be dealt with. And so property, land, and to some extent the question of social and economic rights loomed large as well. And particularly around issues of...
Our Dean of Law, Professor Penny Andrews, who began her studies here in South Africa at what was then the University of Natal, Durban, but then went on to Columbia University School of Law in New York. Penny's teaching career began more than 2 decades ago at La Trobe University in Melbourne, Australia, and she has since been tenured at 4 law schools. She is a member of the New York State Bar Association and the American Bar Association. Professor Andrews has published 4 books and more than 50 articles and book chapters focusing on international human rights law, comparative constitutional law, gender and racial equality, and the judiciary. She was appointed as UCT's new Dean of the Faculty of Law in January 2016, and therefore it's a huge honor to be able to welcome her here this evening.
Thank you, Fionnuala, for that introduction. And thank you, Matthew, for putting my speaker on. And good evening, everybody. So tonight, I normally know when I'm teaching constitutional law where everybody is in terms of their learning. So maybe it's a first year or second year and so on. So I don't know where all of you are in terms of your own careers, how many of you are lawyers, how many of you are constitutional experts and so on. So if I bore you to death because you know everything, I apologize, and I hope that for those of you who know nothing about constitutionalism or very little, I've tried to accommodate you all and sort of think about 20 years of constitutionalism in context, looking at the history and so on. Initially, I was supposed to be the third in the series, but the first speaker couldn't come, so my task has changed a little bit because this is the first